This is the NRC Black Table Talk Podcast. Happy Monday, everybody. Today is May 20th, 2024. It's around 11 o'clock. We got a very special guest here today, and he's going to shed some light on some things that's never really been spoke about, even though we hear about it all the time. But before we do that, my name is Travis Register, your host, and my co-host is
Foster Sellers.
And our special guest, please say your name.
Leslie.
Hey, Leslie, how you doing this morning?
Doing real well. Thank you, Travis.
I know you're welcome, and I know you're here to shed some light on this thing they call IRAA.
Exactly. So a couple of words about who I am.
Yes.
I'm a lawyer, so don't hold that against me. I'm in my 70s. You can hold that against me. So I've had a long career as a private lawyer, mostly in New York, a little bit in the district. I moved down here about 8 or 9 years ago, became admitted to practice in the District of Columbia, started finishing up my law practice, ran out of clients basically, and then became aware of something that is wonderful in the District of Columbia. And that's what I'm here to talk about today. It is a statute. Statute is a fancy word for a law that was passed by the City Council of the District of Columbia, approved by the mayor, and believe it or not, the U.S. Congress let it go through. So it is now the law, and it was passed initially in 2018, and it's called a Sentence Reduction Act. It's called IRAA. The formal name is Incarcerated Reduction Act Amended, and that's what we're here to talk about today. So what are we talking about? We're talking about a law that allows qualified people who have committed crimes in the District of Columbia while they were under the age of 25 to apply to the court for a reduction of their sentence. In order to be qualified, in order to meet those qualifications, you have to have committed the crime while under the age of 25, and you have to have been incarcerated for at least 15 years. And that makes you technically eligible to apply to the court through a lawyer for a reduction of your sentence. So what are we not talking about? We're not talking about challenging your guilt or innocence. That doesn't come into play. We are not talking about challenging the initial sentence. That doesn't come into play. What we're talking about is whether you can convince the court, and when I say the court, I mean a judge, a male or female superior court judge in the District of Columbia, that two things come into play. You are not the person who committed the crime 15 or 20 or 20 plus years ago. You've changed, you've grown, you've matured, you've educated yourself, you've calmed down. And so that's one very important thing. And the other thing that the judge has to decide, almost as an initial matter, is that you are no longer a danger to society. And so there are lots of ways a judge can approach that, but those are the two things that come first. And once a judge determines, based on a number of metrics that I'll talk about in a minute, that you're not a danger, that you're unlikely to be a danger to society, and that you've grown and matured, and that it is in the interests of justice that you be released, then the judge has a number of factors that are laid out in this law that he or she has to consider. So I'm going to go through those factors. Some of them are important, some of them are less important. But I want to step back for a second and talk about what we're really involved with here.
Okay, before you get to that, you said something about qualifying and everything. So once an individual is qualified, how does an inmate get notified that he is qualified for this type of law?
Well, very good question, Travis. So one of the reasons that I'm doing this today is to spread the word. Qualified means nothing more than committed the crime in the district under the age of 25, incarcerated for 15 years. If you meet those three criteria, you are qualified.
Okay.
So that means that you can reach out to a number of organizations in the District of Columbia, the Public Defender Service, the Second Look Project, the Georgetown Law Project. All of those organizations hire lawyers to represent people to make the plea to the judge to release them. So one of the things that's important, and why am I here? Because I want all of you to know that this exists. You can go on the internet and find organizations in Washington, D.C., and you can contact them.
Okay.
If you were represented by the Public Defender Service in the initial trial or plea or whatever happened 15 or 20 years ago, you should expect to receive a letter from them when you become eligible, or shortly before you become eligible, which means shortly before you reach that 15-year threshold of incarceration, assuming that you were young, under the age of 25 when you committed the crime. You don't have to wait for anyone to contact you. There are also private lawyers who take these cases pro bono, which means free of charge.
Mm-hmm.
You're never going to be charged for this. There are law firms, big law firms, that want to give back to the community, and they hire lawyers to do work like this, pro bono work to serve the community. So there are lots of ways that you can reach out and find people to represent you. In some cases, people will reach out to you and tell you that you're eligible.
That's awesome. I think it's really good how our listeners and the general public can learn about this particular statute and how they can benefit from it if they are in the BOP and needing this type of service.
Yeah, it is a wonderful statute, and personally, it's been a tremendous journey for me. I've represented a number of incarcerated guys who have been in from anywhere from 18 to 25 years, and 5 of them have been released into probation.
Okay, you batting 1,000.
I'm batting 1,000. 5 for 5, but past performance doesn't guarantee future results. And these are difficult cases. Even though you're eligible, it is far from automatic. The cases are generally opposed by the U.S. Attorney's Office. That's the prosecutor's office in the District of Columbia, and they do everything they can frequently to keep the person in.
Right. That's their job.
That's their job.
Yeah.
But I have to say the judges take this very seriously. I'm going to get into some of the details of what the judge has to look at by the statute. But one of the main reasons that I want to talk to everybody is to give people a sense, first of all, of what it takes, to what the statute says. So that'll be number one. And number two will be, what are some of the strategies that you guys can use? And I'm talking to people who are in.
Okay.
And I'm talking specifically to people who are not qualified yet, meaning maybe they've been in for 3 years. Maybe they've been in for 5 years. Maybe they have a 20-year sentence. Maybe they have a life sentence. They're not going to be eligible for 5, 10, 12 years. What can we do now? What can you do now to start preparing yourself to heighten the chances, to increase your odds of succeeding in getting out and being released once you become eligible? That's the most important thing, really. If you've been in for 25 years and you have misbehaved, you have a bad disciplinary record, you've gotten into fights, you've been taking drugs, imagine a judge wondering whether I should release this person. You have to keep the judge, try to imagine what the judge is going through in terms of a thought process. Mm-hmm. The last thing a judge wants to do is to release somebody under this statute and have the person reoffend. Right. That's a nightmare for the judge. It's a nightmare for all of the people who support this kind of second look approach. It's a nightmare for all of the people who have stayed the course, because it makes them, it reduces their chances of getting out.
Right.
So let me first talk about what the statute says.
Okay.
So I've said already, qualified. crime in the District of Columbia committed under the age of 25, minimum of 15 years incarceration. And then you're qualified. Means you have a right to bring a motion, which is a written argument backed up by lots and lots of other things that I'll talk about, in front of a judge, and then you get a hearing, and the judge makes a decision. And if the judge grants the motion, usually what happens is that you get released into supervised probation. It's not parole, it's probation. It's supervision under the District of Columbia's CSOSA program. Has nothing to do with the parole board or anything like that. It's actually much better, and I'll explain that in a little bit too.
Can I make a statement before you go any further?
Sure.
Because like for the listeners to also understand the process that it goes through, because with this IRA, you're not being brought up on what you're doing or on what your crime is about. It's more so the trauma and things that you may have went through during your time of when you was a youngster.
That comes into play. The whole concept of this is that when you're under the age of 25, your brain has not really fully developed. You're still a growing person. You're not as responsible in the eyes of the law, in the eyes of this statute, as if you committed the same crime at the age of 40 years old, because then you're a mature adult. Right. You're basically kind of a kid developing. And the younger you are when you committed the crime, the more that's true. If you were 16, 17, 18, you were young and dumb. We've all been young and dumb. And that's really the basis of the statute. So, what are we talking about here? You're qualified. A judge has to make a determination of whether you are dangerous. He has to decide, or she has to decide, that you are not dangerous. And that's based primarily upon your disciplinary record. And it's your disciplinary record really for the last 10 years or so.
Okay.
That's much more important than your disciplinary record when you first came in. When you first came in, you were scared. You got into some bad stuff.
Impressionable.
You're impressionable. You're being dominated by older guys. Judges understand that. Mm-hmm. But by the time you've been in for a few years, what have you done in the last 10 years? That's really the main focus. We all know that weapons are all over the prisons. We understand that. The courts understand that. So if you're caught with a weapon, for example, that's one thing. If you use a weapon, that's a completely other thing. Mm-hmm. So what they're trying to do is be understanding that prison is a horrible, dangerous environment and you have to protect yourself. But that's very different from going after other people.
Right.
And if you're part of a group that goes after other people, a gang or something like that, even though you're eligible, honestly, you're not going to get out, because a judge is going to look at that disciplinary record and say, this is a person who has not grown and matured. He's still doing the things that he did that got him in the first place, and he's likely to do those things once he gets out. And it's up to me to decide whether he stays in or gets out, and I'm keeping him in. I'm being very honest with you guys.
Mm-hmm. I was going to say that's a good point, Leslie, as far as, who you're becoming, how you're maturing, how you're growing while you're in the BOP, because it's going to play a factor into whether or not you're eligible for this, because the judge is going to look at who you've become as far as your character, and then as well as, are you a danger to society?
Exactly right. Exactly right. So what are some of let me go through the points in the statute quickly. Once a judge decides that you're not dangerous, and the BOP rates you as dangerous or not, rates you under the pattern program and gives you a number which is your risk of recidivism, and it rates you in terms of the likelihood that you're dangerous. So the judges understand this, and they are guided to some degree by what the BOP has already determined about your history. So it makes it a little bit easier for the judge to make that initial determination.
Okay.
So, and that's one of the benefits of the First Step Act, which applies to people incarcerated in the Federal Bureau of Prisons. It exists only on that federal level, and it can give the judge a little bit of comfort. There are some people who have a spotless disciplinary record. That's the best thing you can possibly have. There are other people who have the act doesn't require perfection. It requires substantial compliance with the rules of the institution. And everybody knows that, perfection is the enemy of good. You have to be good. You can't be bad, put it that way.
Makes sense, yeah.
So I'm reading now. The
Okay.
court, in determining whether to reduce a term of imprisonment pursuant to this act, shall consider, 1, the defendant's age at the time of the offense. So the age has to be under 25. That's kind of a given. The history and characteristics of the defendant. What does that mean? How is this person raised? Was there a mom? Was there a dad? Was the person in social services, in foster homes? Was the person living in an abandoned bus? I had a client that spent years as a kid living in an abandoned bus.
Wow.
Yeah.
And this is very different from the way so the judges were all raised by families, and they had a mom and a dad usually, and they went to law school and they went to college, and they were wearing nice clothes.
Very functional.
Very functional. But 20, 25 years ago, the District of Columbia, in certain neighborhoods, and we know what those neighborhoods are, it was a war zone. There was drugs. There were
Absolutely.
There were old guys, picking up young guys and recruiting them to be runners in drug organizations. Everybody had a gun. Guys had guns. Girls had guns. Everybody was getting high. Everybody was getting drunk. And it was a complete systematic failure in the part of the District of Columbia. The schools were war zones. Some of the schools had fences around them because it was so dangerous to be in school. And the judges understand that. So this second, the history and characteristics of the defendant, how traumatized were you as a child growing up, and what effect might that have had on the crime that you committed, and the basic sense of law and order and playing by the rules disappears when there's no parental guidance, no school guidance.
That's right.
And then you're much more likely to get into trouble.
Absolutely.
So that's what this is all about. Then number 3, I've touched on this already, whether the defendant has substantially complied with the rules of the institution to which the defendant has been confined. So that's half of it. So we talked about that. You need a good disciplinary record, not a perfect one,
Right.
but a good one. And the thing that you have to stay away from is aggressive behavior. It's one thing to defend yourself. It's another thing to go after someone. And if there's a pattern of going after people and getting into fights and being caught with weapons, your chances of being released are going to be reduced. It's common sense. So that's one thing I've talked about. And then the second part of this, which is equally important, and whether the defendant has completed any educational, vocational, or other program where available. So the BOP is good news and bad news. It's bad news because the BOP can put you, in Utah and wherever it wants to, and you're not going to get visits from your family. That's bad.
Right.
That's
bad.
Right. And it's incredibly difficult for people, young people, not to have any visits from family members because they can't get out to, I'm making this up, Utah. But the good part of the BOP is that there is programming, educational programming, vocational programming, behavioral programming that becomes available to people. There's a requirement that you spend time getting a GED, and the data, the research shows that for people who have achieved a GED, the risk of reoffending drops statistically because they've gone through the discipline of learning and educating and focusing on their education. So the BOP makes you do that and makes you spend I think up to 2,000 hours.
That's right, 2,000 hours, and you get disciplinary reports if you skip out of class.
Exactly. So what is
Wow.
what is happening? They are trying to convert this, and most of the people that we're talking about are guys. I mean, there are some women who are eligible, but in order to do 15 or 20 years, most of the crimes are homicides. You don't get 15, 20 years for jaywalking,
Right.
or even for shoplifting or even burglary. Those are lesser sentences. We're talking about people who have killed other people. So let's just put that on the table for the most part. All of my clients, every single one of them, was convicted of some form of homicide. So you have to stop that attitude. You have to, and how do you do that? If anger management is available to you, do everything you can to get into an anger management class. If a drug program becomes available to you, jump at it. Jump at it.
Right.
And not only jump at it, work it hard and become a trusted member of that class. And if you can get, for example, one of the people I represented had a statement in the record saying, this person assisted me in running this class. And when a judge sees that, what is a judge going to think? This is a person who's ready to come home.
Right.
Leadership.
So the strategy is do your best to get into all of these programs, and if they are not available to you, create a paper record via email of trying to get in, so that at the end of the day, when the government says the person never had any programming, you can show that you did everything you could to try to get into it, but it wasn't made available to you.
You can also do correspondence courses through local colleges.
Exactly. Or ask family members to send you anger management workshop books and work at it yourself. Because generally, what are we trying to do? We're painting a picture of a person who is struggling to become a better person, to become a calm, educated person who is not likely to get into the same kind of bad behavior that resulted in the incarceration in the first place.
Mm-hmm.
Always think about what a judge might be looking at in terms of modulating your behavior and developing an attitude within the prison system. So any report or recommendation received by the U.S. Attorney, that's meaningless because they're just going to oppose. And they lie. They do everything they can to keep you in, frankly. And they ignore all of the good things that we say and they'll focus on the crime itself.
Yep.
They'll talk about how bad the crime was. And the statute, you'll see, doesn't refer to the crime very much. It's really about the journey, not, all of the crimes were bad.
Mm-hmm.
If it was focused on the crime, nobody would get out because they're all bad. So it's really what has happened in the last 15, 20, 25 years. So the victims of the crime, the family members, or if it wasn't a homicide, the injured person, they can weigh in against this. And they can write in support of keeping the person in. But that's just one factor of 9 or 11, actually, that the judge considers. So the judge will consider that, but it's not going to carry the day if you've demonstrated all of the other things that I've been talking about.
I was wondering that because I know when you go to a parole board, the family they can present a heavy factor in you not coming home.
And this is so much different from parole. That's the beauty of this thing. It's not a parole commission that's making this decision. It's a judge that is bound by these factors, and your chances are much better. The judges are sympathetic. The judges live in the District of Columbia, or they work in the District of Columbia. They know the history of what happened 20, 25 years ago. Parole commission can be anywhere, and they can be politically appointed people. They are unsympathetic. The chances, that's the beautiful thing about the District of Columbia and this statute. It doesn't exist everywhere in the country. It exists in about 20 or 21 states, but it is not as good a statute as this one. So in a strange way, I hate to say this, but you're lucky that the crime was committed in the district, because if you're eligible for the best possible chance of getting released into probation.
I like what you're saying, Leslie. It's a good point, because it seems as though if a person is committed to their character and how it counts towards another human being, the judge's perspective of them, then they have the power to do everything in their ability to show up, for themselves, and hopefully stay on the right path, and hopefully get the outcome that they want when they go file the motion.
100%. And that's, to me, one of the great things about this statute is that it gives people a guidepost. It gives them a sense of what they need to do to convert their life from a life that might be a life of full incarceration for the rest of their life into becoming a member of society, a productive, peaceful, supportive member of society. So I'll get back to that, because there are other strategies that we can, but I want you to understand what a judge is looking at in this statute. So another thing that it says is any reports of physical, mental, or psychiatric examinations of the defendant conducted by licensed healthcare professionals. So in representing my clients, what might I do? I might hire a forensic psychologist to come in to the prison and interview my client and make a determination based on a very well-accepted risk recidivism program of the chances of future violence and recidivism. Recidivism is reoffending, basically.
Okay.
So a psychiatrist will come in and conduct a 3-hour interview, and it's a well-recognized test, and the test will likely determine that the person has a very low risk of recidivism, and that will give the judge a little bit more comfort in saying, okay, I'm gonna really consider letting this person out, because this is a licensed professional. And we wouldn't hire a person like this who's charging money to come in and interview someone with a bad disciplinary record, because the result of the interview is going to be, well, there is a high risk of recidivism, and that's exactly what we don't want. So if you have a good disciplinary record, if you've kept calm and peaceful, we can use this as a tool, as yet another tool to convince a judge to let you out. Your disciplinary record. There are lots of reasons why disciplinary incidents happen in the prison. And there are specialists who we can also hire as expert witnesses on these motions, who have vast experience within the Bureau of Prisons in understanding why it is that people get into trouble. For example, there are certain prisons and certain times within prisons where it was so dangerous that you actually had to have something to protect yourself. And these experts can put that into a context and explain to the judge that just because you're caught with a shiv or with a sharpened weapon doesn't mean you're violent. It means that you're scared, basically. You're young, you're scared, and you see everybody else having one, and if you're attacked, you have to be able to defend yourself. So, and that's very different from going after people and being violent yourself. So that's a strategy.
It's a good distinction.
Yeah. I mean, everybody knows that these are incredibly dangerous institutions.
Very hostile.
And very hostile. And you can look at somebody in a bad way, and the guy's going to attack you. And we all know this, and the judges understand this. So, but I'm making the distinction between passive and active.
Gotcha.
All right, another really important thing, the defendant's family and community circumstances at the time of the offense, we've talked about that, including any history of abuse, trauma, or involvement in the child welfare system. Some of my guys were abused by older siblings, by people in the neighborhood, by their parents. It's terrible. Mom was a crackhead. I mean, Mom was doing anything. And that factors into the equation. It creates a more sympathetic view. Why did this person do what the person did? Well, you know, who knows? I mean, the stories are terrible.
Right. But it definitely factors in.
It certainly factors in. And one of the things that we present to the judge is a very, very full and complete picture of who the person was, growing up as a 4-year-old, a 3-year-old, a 2-year-old, a 7-year-old, a 9-year-old. And then by the time the offense was committed, maybe the person was 17, 18, 19, 20. But there's been a history of trauma and neglect and truancy from school. Nobody reached out and grabbed this kid and elevated the kid.
So it sounds like the more you went through, the better off you are coming to the IRA. Sad to say.
Sad to say.
But glad to say.
Sad to say.
That's
but
a good point, Mr. Register. Yeah, you're right.
Yeah.
What we're talking about is increasing your chances of success. Mm-hmm. And Mr. Register is right. I mean, if a judge sees that this poor child was abandoned, basically, and had no family, that's going to create a little bit more sympathy for the person. It's not going to be the determining factor, but it's going to help. This is like we're building blocks. We're painting a picture, and that's part of the picture. Mm-hmm. So another aspect of it is the extent of the defendant's role in the offense and whether and to what extent another person was involved in the offense. What does this really mean? You're 17, and there's a dude that's 25, and he's got you, and he's got you under his wing, and he's bad, and he's telling you what to do, and he's dominating you. And, and you know, if it weren't for him, maybe you wouldn't have done what you did. So that's what that's looking at. And it's really important. It's really important.
Yeah, peer pressure is real, and the influence on a youngster can happen by anyone.
You're exactly right. So it's just another factor. Sometimes that comes into play. Sometimes it doesn't. Sometimes you're, like you didn't have anybody with you when you pulled a trigger or you did something all on your own. So that doesn't help you, but it doesn't hurt you particularly. Mm-hmm. And then the last one is what we talked about before, too, the diminished culpability of juveniles and persons under the age of 25 as compared to that of older adults, and the hallmark features of youth, including immaturity, impetuosity, and failure to appreciate risks and consequences, which counsel against sentencing them to lengthy terms in prison, despite the brutality or cold-blooded nature of any particular crime and the defendant's personal circumstances that support aging out of crime. This is an incredibly beautiful thing because it puts a little bit of mercy and understanding back into a justice system that is harsh to everyone and particularly harsh to black people.
Well put.
And
Absolutely.
we know this, and it is undeniable. You can go through any statistical analysis, and you will find that the justice system lands most heavily on African American people in this country, and it's undeniable. And you can come up with all sorts of reasons why that is the case, but it is the case. Mm-hmm. So this statute is one step, an important step in the direction of unscrambling that egg and giving people a second chance to live a life, people who have demonstrated that they're ready to live another life. So, that's basically it. So what happens? How does it actually work? You've determined, or you've been determined to be eligible. Mm-hmm. Beyond eligibility, you've been determined that there's a chance that you can succeed, and that's a judgment made by the lawyers. Basically, the lawyers who have experience in winning and losing these cases will be able to make a judgment on your chances of success.
You said wins and losses, or judging on whether they can win the case or not. Just like there's probably ain't no stats, but just off your opinion, how many IRA cases do you think been won as opposed to as many been lost?
Very good question. So we have to remember that many IRA cases, many guys, people who are eligible, don't get to have an IRA case because they're not going to win. So the ones that are chosen, it takes a year of hard work by a team of lawyers to put one of these cases in front of a judge. You have to understand that. And it also takes money. Most of the people working on these cases are paid employees of organizations, Public Defender Service and the like. And these organizations have limited resources. So they're not going to squander their resources on losing cases. So the cases that are picked up are cases that have at least, say, a 50% shot at winning. And if you are picked up, you have a very good chance, maybe a 60 or 70 or something like that chance of succeeding.
Gotcha.
And with the understanding that you might be eligible and no one's going to pick up the case. It's important from the standpoint of this whole enterprise that a number of things happen, that the people who are released stay out of trouble. If somebody is released under IRA, commits another homicide, the whole thing starts to collapse.
Right.
And people start thinking, this is a ridiculous statute. Look at what just happened.
Right.
You know, this guy, we tried to keep him in, some judge let him out, and look what happened. And that's going to make it more difficult for every other person who should be released but won't be released because the whole attitude changes. We all know right now that crime in the District of Columbia is a huge political issue. People are talking about it all the time. We know that the crimes that they're talking about are not being committed by people who are released on IRA. For the most part, the recidivism rates of people released on IRA are a tenth or something like that, what they are in the general population that get released out of just serving their time. Because these are people who have disciplined themselves and done whatever it takes to become a real productive citizen. They haven't just waited until a release date and then gotten back into the same behavior. It's very, very, very important, very different. And what are some of the things that have occurred that I've seen that have helped people build a record? So the lawyers build a record. That's what we do. We hire experts, but we do much more than that. For example, if you have become a mentor in the prison system to youngsters coming in, and you have tried to share your experience and your growth and strategies for keeping out of trouble, and you can demonstrate that to the court, that's another beautiful thing.
Absolutely.
That's another beautiful thing. And it's not just, whether you get released or you don't get released, it's still a beautiful thing. Because what you're doing is you are gaining spiritual purchase, and you are actually thinking about people other than yourself. And you're trying to help other people. And that is a journey that is going to help you whether or not you ever get out, I believe. And it's certainly going to help you in increasing your chances of getting out. So imagine a guy that's been in for 10 years. He's sort of, the light bulb has lit, and he's now in contact with young guys coming in. And he sits down with them and he says, all right, you got two paths here. You can stay a bad boy if you want. You can just continue to misbehave. And I'm not going to have anything to do with you because you're going to screw me up. But if you're willing to listen to me a little bit and start on a path of growth and maturity, I'm there to help you. And I'm going to do everything I can to give you advice, to keep you out of trouble, to give you some strategies for keeping yourself out of trouble. It's all going to be up to you. No one's going to be able to do this except yourself. But I'm going to be there to help you. And then you do that, and you do that for more people and more people. And then at the end of the day, you've helped these people.
True.
And what do? They write a letter. And that letter becomes an exhibit in the motion that the lawyers make to the judge. And the letter says, I came into the prison system. I had no idea how to behave. And I met John Doe. And he took me under his wing. And he guided me. And he became a friend. And he helped me stay out of trouble. And he showed me some of the things that I needed to do to become a better citizen. And my client has 7 or 8 of those letters. And what is a judge going to think? Judge is going to think, this is a guy that is trying to give back to a community in the most difficult circumstances possible, a prison system that is dangerous, violent. And he's trying to help people navigate through this circumstance.
So he'll be an asset to the community once free.
Well, I mean, he's a teacher now.
Yeah.
He's an evolved person.
Right.
He's a parental type of person, even though he's not the parent. He's helping other people. That's one thing. Another thing, keep in touch with your family. Even though you're in jail, you're in prison, if you have children, be a mentor to your children. They will visit you. You can talk to them on the phone. If you have a woman in your life, be kind to that woman. Help that woman. Do everything you can. Don't try to give, not take, even though you are in this circumstance. So that the woman or the family members, doesn't have to be a woman, can be anybody, can say to the judge, if you release this person will come into my home. Mm. And I will surround this person with a community of family and friends, and we will make sure that the person stays on the straight and narrow. That's another incredibly important thing. It's called a reentry plan. Mm-hmm. Another aspect of the reentry plan is work toward an actual job that you can do when you get out. I've heard of people who have met people along the way who get released. They've become mentor, mentee. The person who gets released gets a job and hires and says to the court, if you release this person, I will give him a job for a living wage. Maybe it will be janitorial services in a hospital. Maybe it will be driving a truck once the person gets the
CDL license.
Yeah. But a job is waiting. Mm-hmm. I mean, a judge does not want to release you onto the streets with no support.
Right.
There's tremendous support that's available in the district, but you can build your own support. Mm-hmm. And that's incredibly important. If you've had children, maybe you have maybe when you went in, you had a 2 or 3-year-old or a couple of kids, work your hardest to stay the family member, the father of those children,
right,
even though you are incarcerated, mm-hmm. and share your own growth and maturity with those kids and get those kids to respect you as a parent and a father and do for them what your own parents might not have done for you. Yeah. And that is be a role model, even though you're a criminal, a convicted felon.
Right.
You can still be a father. You can still be a calm, guiding person. And then when it's time to make the motion to the court, the child can write a letter. The child is now going to be not a child. It's going to be at
grown
least,
up.
a grown-up.
Teenager.
A teenager. And the child can say, I love my father. My father has helped me through my own struggles. And even though he is incarcerated, please let him out because I want him to become part of my life. And again, we're thinking about what a judge would be listening to and what is important for a judge. How is this not important? It's incredibly important.
I like how you're talking about building this narrative of an individual who has been just as impacted, going through possibly being released on the IRAA, and how it does take a community to come together to tell this story so that, a positive outcome can transpire.
Exactly.
Support.
Exactly.
and it's practical things that a person can do. Like like we're giving nuggets and helping a person who's hearing our message today. And what you're talking about, Leslie, is it's really impactful and beneficial to digest all this information that we're sharing.
This statute exists, and it exists to undo a lot of harm that was done many, many years ago. It exists to give people a chance of life. I said initially, I'm in my 70s. The people who have come out through the work that I've done, but many, 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 many other lawyers have done through organizations and private practices, there are over 100 people who are out. And all of those people are, not all of them, but most of them are in their late 30s, 40s, and early 50s. They have a whole life ahead of them. And that life is not within the walls of a prison. It's out in a community where they can help other people, where they themselves can right the wrongs that were done. They can transform. I mean, I'm getting a little emotional now, but it's incredibly important to me and to the community at large to raise us all up. Mm-hmm. So another strategy that I've seen work, and these are all strategies, meaning you can choose them or not choose them. The element of faith. People come in, often maybe mom and dad took them to the church every now and then, something like that. But within the prison system, there are groups of people who are very serious about religion and faith. There's the Islamic community, there's the Christian community, there's the Rasta community. Mm-hmm. Those are the three that I have experienced in terms of working with my clients. And what you believe or don't believe is not as important as what these communities can give you by way of finding a way to discipline your mind, to focus on faith, to read the Quran, to understand what Rasta is. Because all of these religions basically point to the same place, and that is become a person of faith, a calm person, a nonviolent person. And if you can use faith and the community that surrounds that faith as a way of getting through the nightmare of prison, go for it.
Go for it.
Go for it. And if it doesn't work for you, find another way. Mm-hmm. There are lots of other ways. There's an organization called the Free Minds Bookshop Workshop. They provide reading material and teach you how to write. And they exist. You can contact them, and they will provide you with books. Mm-hmm. Learn to read books. Learn to better yourself through the wisdom of writers and authors who have written books. The books can be fiction. They can be history. They can be self-improvement. Learn to... I'm not commanding anyone to do anything. This is the way I speak. Yeah. These are just strategies that you can use that will impress the court. If you have learned to write fiction or poetry, if you have worked with other people in a group writing poetry, it sounds kind of weird, but you're expressing yourself.
That's right.
And maybe you're expressing remorse for what you've done. Maybe you're expressing a way of changing your life. Correct. Maybe you're expressing a way of helping other people change their life through something that you've written. And the Free Minds Workshop will publish this and will create a pamphlet. They create a pamphlet that gets sent to people who are interested all over the inmates in the Bureau of Prisons. Mm-hmm. And it becomes a community of readers and writers. And this is very different from a community of violent people. So, gang members. Right. So what community do you want to join? If you want to join a community of authors and writers and poetry readers, a judge is going to go, wow, that's, kind of cool.
I it raises your eyebrows, and it is very cool. Um, it's interesting how we're talking about now strategies on which inmates can take in order to move forward. And you're absolutely right, Leslie. Like this is about self determination. This is about character building. This is about changing the narrative and changing the language of what someone has perceived you to be. And you are in charge of that, and you play a vital role in that when going through the motion.
I wish I could have said it as well as you just did, because that's exactly what I'm trying to express. This is up to you. This is people can help you along the way, but you have to pull your own trigger on this. And really, who am I speaking to? I'm really addressing this to people who are coming into the system. If you've been into the system, if you've been in for 20 years, you've either done this or you haven't. And it's very hard to change once,
What's done is done.
What's done is done. But if you're at the point where you're just entering the path and, the road takes many different variables and you can choose which way you're going.
Mm-hmm.
And that takes work and determination. But it's really a decision that you have to make. Have to if you want to increase your chances of being released before the end of your sentence. This is a sentence reduction act.
Very well put.
So
very well put.
A judge is going to either reduce your sentence or not reduce your sentence. And if you want to do everything you can to convince this judge that you are deserving of a sentence reduction, these are some of the things that you can think about. And there are many, many, many more. But really, what am I talking about? Do your best to be a good person within the prison system, no matter how hard it is.
Mm-hmm.
Okay.
That's it. I mean, that's really it. And there are lots of ways you can do that. But if a judge determines that you're not going to be a violent person when you come out, that you're going to be able to support other people in the community because you have a track record of supporting people in this community, the prison community, these are items that are going to make it easier. It's hard for a judge to release a person convicted of a homicide before the end of the term. It's hard. It's a very risky proposition for the judge, because if the judge makes a mistake, the media is going to be all over that judge. The appeals courts are going to look, down at the judge, and you know what happens. That it's just a very bad outcome for the judge, for the whole program, and for the people who support this notion that people deserve to have a second look at their sentence. So that's pretty much it. That's what I have.
I was just going to add, like, we don't want to lose sight on what we're talking about now as far as focusing in on that. We all play a part in dropping this, rock in a pond and having that ripple effect. So let's be mindful of individuals who are in the BOP who are thinking about their second look and how they're going to navigate that space, and not do it in vain, where it becomes about the ego and then burning bridges basically for others who may come behind them or who want to take advantage of this type of program.
I don't need a program. It's the law,
Right?
not a program.
Well, it's both.
Yeah,
it's really
them
both.
as a program in prison, but in order to make the law shine to where it has, up to the present time, and to have it continue on doing so, we have to do our part, or they have to do their part while they're in prison, to make sure that this law doesn't get eradicated.
Exactly. It's under a lot of pressure. The attitudes of a lot of people in the district are keep them in. I mean, there's a whole group of citizens in the United States who believe that you commit a crime, stay in.
Mm-hmm.
Stay in. And then there's a whole other group like us that say, why keep them in? If they've demonstrated that they're no longer a risk, they can become productive members of the society, let them out.
That's right.
Don't let them out to roam around unsupervised. Let them out into a very, very rigorous supervision program monitored by probation authorities, where they go through drug testing, random drug testing, where they have to live in certain places. They're not released into freedom. They're released into a community, and they're supervised.
Right.
And if they reoffend, if they don't follow the rules once they are released, a judge can put them back in a heartbeat and reimpose the original sentence, and back they go. So that's another incentive for them to, behave,
That's
basically.
right.
Behave and work toward building a life.
Absolutely.
Well, we got to get out of here.
It was a pleasure.
We're thankful for
Yes, thank you.
The informative discussion / interview that we had with you concerning the IRA. For people who don't know, you know now.
All right. Good luck, everyone.
This is the NRC Black Table Talk podcast. We was talking IRA today. And like we always say, y'all, we're signing out, but we're never signing off because there's always work to be done, boots to the ground. We had Leslie here today, y'all, speaking about the IRA. Y'all do good.